It's mid-February 2025 and there's a fresh custody here at Cessnock Local Court. I think we, the community, should hear about this case to manage our expectations about fresh custodies and domestic violence. However, there's no public information about this case, there's no police media releases or media stories. Yes, it's just another AVO breach case, probably one of the many on this day from around New South Wales. Yes, the defendant has allegedly breached bail for existing DV offences, which they haven't yet been sentenced to. Yes, the defendant has a history of DV offending. This is why I think this is a good example to use in having a conversation about our expectations of our legal system when it comes to dealing with DV fresh custodies. Will this convicted and now allegedly fresh offending DV offender get granted bail? Let's unpack. My first observation is he isn't cuffed. Now that's the discretion of the police whether to cuff or not, and here's where my expectations were off. While we wait for him to walk over from Cessnock Police Station, there are some details spoken out loud about his history of DV offending. So with a DV history, I expected him to be cuffed, but he walked in uncuffed with a police officer and two sheriffs, who sat in the dock, and no one seemed to be worried. That's where I realised he might be known to the police and the court, but his history of offending is not towards police officers or people on the roads or people down at the shops or any of us in the courtroom. He has only offended towards one woman, his now ex-partner. I realise all the risk is with one woman. The rest of us are unlikely to be at risk from this guy's offending. My lesson is that I shouldn't assume that DV offenders do crimes to everyone. Sometimes it's only limited to particular people. My second observation is about the woman. I want to acknowledge how the magistrate handled the discussion about the woman. In my opinion, at no point was there victim blaming. Thank you, New South Wales Local Court. The proceedings were kept focused on the guy who was sitting in the dock. The woman wasn't named and really was only mentioned once where they were clarifying if she was the complainant in the previous DV convictions. It's here the magistrate corrects the record, saying the woman is the complainant in the current matters but no longer the complainant in the previous DV convictions. The magistrate clearly reminds everyone the woman is now the victim in the previous DV convictions. There was no questioning of what the woman did, nothing about her behaviour, which was a relief. My lesson was I shouldn't expect to hear victim blaming just because I've heard it in the past. The third and final observation is about bail. A case like this reminds us that bail is about risk, not about starting a jail sentence. Of course, we hear bail considerations, which goes to mitigating the risk. So we hear arguments for and against bail. We hear his criminal history doesn't assist him. It's the same victim complainant in all the matters. He is already on bail for alleged DV. We also hear the guy and the woman are currently going through a property settlement where the current mortgage is dependent on his employment. He has a need to be bailed to work, and it's inferred that this may impact on the woman. But in my opinion, if we only heard one part of the bail considerations, it would be about the Section 5 threshold. Meaning this alleged reoffending may not have crossed the threshold for full-time jail. I argue it's our law that's restricting the magistrate here. Section 5 of the Crime Sentencing Procedure Act 1999, and we're in New South Wales, says a court must not sentence to jail unless it's satisfied, having considered the alternatives, that no penalty other than jail is appropriate. Meaning if the defendant pleads guilty or is found guilty, the sentence may not be jail. Therefore, going to jail now will be more punishment than the actual sentence. They could get a community corrections order or an intensive corrections order. This is a reminder to manage our expectations because it's about bail today, not a sentencing exercise. The question today is not what he should be sentenced to, rather, can they mitigate the risk during the proceedings? It's proposed that on top of the AVO conditions protecting the woman, he must not enter Abermain unless he's travelling through there for court. He will now live in a suburb of Lake Macquarie. In my opinion, the risk and any future DV really is dependent on the actual defendant. I think the court can do bail conditions and ABO conditions, etc. But it really comes down to this individual controlling his own behaviour. Should we expect the court to control a person's behaviour, or should the expectation be on the person? Even if bail is granted or refused, the main focus is stopping the behaviour towards this one woman. What's going to stop the behaviour for that woman? I think hearing about a case like this reminds us of three things. That DV offenders do get granted bail. That DV offending may see the person be bailed more than once during the legal proceedings. That DV offending doesn't necessarily result in a jail sentence. This is how our legal system is in New South Wales. So was bail granted again in this case? Yes, bail was granted.